cordon, my lord, they have made a cordon so that the possession cannot go to the second Hooghly bridge. So they are stopped there. Some commotion because police has, my lord, they have used water cannon, they have used, my lord, the tear gas, and my lord, severe lathi charge was there. Number of person was injured. The petitioner's son was not arrested from the spot. He was, my lord, joining a peaceful procession. In the evening, when he went to a reputed media house for the panel discussion, when he was coming out, he was arrested on the basis of 3, my lord, the FIR. These 3 FIR we have challenged before your lordship, and we also, my lord, prayed for any other cases has been, my lord, registered against the petitioner's son. Let them apprise your lordship's court, and in the meantime, my lord, give us interim bail till they file their opposition. Because this is clear violation of the Honorable Supreme Court's order, and there is not a single evidence where the petitioner has assaulted someone or he, my lord, the attempt of murder can be legal against him. Let them show one single evidence. The petitioner's son has participated for, my lord, attempt to murder. And kindly see where I have been booked. The allegation they have given 120. My lord, kindly come to 120. Kindly come to 120. How these police persons they are acting, my lord, your lordship will understand. They are more concerned to protect the, my lord, the flags of the other political party rather than doing their own duties. My lord, kindly see it once. This is to inform you that on 27/8/2024, this is a suo motu complaint called 120, my lord, 120. Let kindly come to 120. How they are acting, my lord, your lordship will understand everything. What is their actual motive, your lordship will understand from this FIR. This is a suo motu complaint. This is your for kind information that on 27/8/2024, near about so and so hours, information received from anonymous telephone caller that some agitators assembled JL Nehru Road, so and so crossing and being showing their agitation. Accordingly, the undersigned, along with the available force, including the lady force, reported to JL Nehru crossing and commonly known as Dorina crossing and found 150 agitators, including the ladies, under the banner of Paschim Bongo Chhatra Samaj, where, my lord, I have been, my lord, make as a leader of this group, called for Navanno Abhijan by Probir Das, Sayan Lahiri, my lord, Sayan Lahiri is my son, and Shubhankar Haldar, unlawfully assembled there by blocking the JL Nehru Road without any permission of concerned authority, with caused disruption of normal vehicle and pedestrian movement. They raised slogan by shouting over the issue ongoing RG hospital matter. Well, is this a crime? Well, I'm asking myself. Then, well, the next matter. Then they were too violent mode and they were repeatedly appealed not to break the law and order situation and do peaceful protest. But all of these requests fell in deaf ears. Meanwhile, some agitators became agitated. Also damaged some flexes of TMC party, which affixed at a different places in around of the vicinity of the spot. But this is the actual duty of the Kolkata police is doing. After that, they were again repeatedly requested not to do such type.
Very well. Is this the complaint? In
one of the complaint where I have been arrested.
Complaints. The case number must be there.
Yes, my lord. It is case number. Your lordship will find the 199. It is, my lord, FIR number 114, dated 27/8/2029. This is New Market Police Station.
Yes.
My name is there.
Your name is there, and
yes.
You have been arrested in connection with
not
this case?
Not yet. Not yet. Not yet. Because
and
their whole intention is this. They have arrested me in connection with the Moidan police station case.
Where is that FIR?
Well, we could not collect. The petitioner's mother could not collect that. But he got the information. These are the 3 cases where his son has been arrested. Now, my lord, other 2 cases where, my lord, I am praying for quashing along with this FIR. Your lordship will find not a single allegation so far as all are suo motu complaint. Not a single allegation against the petitioner's son. He actually attempt to commit murder of someone. And if person, they will say that one police personnel, now it is widely circulated in the media that one police personnel, one person has thrown brick bats and he injured with his eyes. Now they are showing all over the media whether, so far as this act is concerned, whoever has done it, let him face the consequences. The petitioner's son, whether he has done this act or not, my lord, kindly consider that also. And whether this is their case, his son has thrown this, my lord, the brick bat. And my lord, kindly visualize the situation once. My lord, the protest rally was going on. At least 5,000 to 6,000 police personnel, they were blocking them from everywhere from the city. Water cannon was used. Tear gas was charged. Some of the, my lord, the participant of the mob, they maybe became violent and do certain acts. Whether the petitioner will be responsible for that or not. That is the whole question. And whether the detention of the petitioner is anymore is required or not. Admittedly, he is a student. He is, my lord, completed his MBA in the year 2023. My lord, we have annexed all the document. And your lordship, I shall place one judgment of the Honorable Supreme Court to, my lord, which says the role of the court when the, my lord, there is a police access.
Para 67 আচ্ছা তার আগে কি প্যারাগ্রাফ 30 টা প্লেস করে কালকে রাত্রে বেশ ফরওয়ার্ড
দাঁড়াও, ওটা পরে করছি। My lord, kindly turn to para 67. Whether, my lord, sitting in a 482 jurisdiction or 226 jurisdiction.
Mr. Mojumdar, if you could kindly give the citation.
Shraddha Arnab Goswami, you know better than me. You have read this more than I read.
Yes, yes. Arnab Goswami.
Lord, para 67.
Yes.
Human liberty and role of courts. Human liberty is a precious constitutional value which is undoubtedly subject to regulation by validate enacted the legislation. As such, the citizen is subject to the edicts of criminal law and procedure. Section 482 recognizes the inherent power of the High Court to make such an order necessary to give effect the provision of CRPC or to prevent the abuse process of law and otherwise to secure the ends of justice. Decision of this court required the High Court in exercising jurisdiction under Section 482 to act with circumspection. In emphasizing the High Courts must exercise this power with a sense of restraint, the decision of this court are found on the basis of principle that due enforcement of criminal law should not be obstructed by the accused taking recourse of artifacts and strategies. The public interest of ensuring that due investigation of the criminal protect the ensuring the inherent power of the High Court is exercised with caution. It is indeed one of the safeguard end to the spectrum. The other spectrum is equally very important. The recognition, Section 482, the power inherent by the High Court to prevent the abuse of process to secure the ends of justice in a value safeguard in the protecting liberty. The Code of Criminal Procedure 1998 was enacted by the legislature, which is not subject to the constitutional right and limitation. Yet it recognized the inherent power under Section so and so post-independence. The recognition by the Parliament of the inherent power of the High Court must be constructed with an aid of to preserve the constitutional value and liberty. The writ of liberty runs through the fabric of the Constitution. The need to ensure the fair investigation of a crime is undoubtedly important in itself because it protects at one level the rights of the victim and the more fundamental level the societal interest in ensuring that a crime is investigated with dealt with in accordance with law. On the other hand, it is important. The misuse of criminal law is a matter of which the High Court and the lower courts of the country must be alive. In the present case, the High Court could not have been cognizant of the specific ground which was raised before it by the appellant. He was made a target as per the serious consequence for which is the taking place in April so and so. The specific cause of the appellant, he has been targeted because the opinion of the television channel, the authority. However, the appellant entrusted for the case quashing of the FIR of the High Court to take final view on the proceeding are listed so and so, the FIR and the High Court. The court, the sentence started with the court. The courts must be alive to do the safeguard of the public interest in ensuring that due enforcement of criminal law is not obstructed. The fair investigation of a crime is aid to it. Equally, it is duty of courts across the spectrum, the district judiciary, the High Courts and Supreme Court, to ensure that the criminal law does not become a weapon of selective harassment of citizens. Courts should be alive to both ends of spectrum. We need to ensure that the proper enforcement of criminal law on the one hand and a need on the other end of ensuring that a law does not become rush of targeted harassment. Liberty across the human era is tenuous and tenuous can be. Liberty survives by the vigilance and as citizens and a company of the media and the dusty corridors of the courts alive to rule of law. Yet so as often liberty is casualty when of this component is found warranting. Mr. Sibal, Mr. Desai and so and so are undoubtedly right. Submitting the procedural manner, it is very important. Hierarchy of the court is matter of concerning the grant of bail needs to be respected. However, there was a failure to the High Court of discharge its adjudicatory function in two levels. First, declined evaluating the prima facie of the interim stage in a petition for quashing of the FIR as to a arguable case has been made out. And secondly, in declining interim bail as a consequence, its failure to render a prima facie opinion at the first time. The High Court did not have the power to protect citizen by interim order to in the petition invoking 226. Where the High Court failed to do so, this court would be abdicating its role and functioning in a constitutional court if it refused to interfere despite of the parameters of the interfering being made. The doors of the courts cannot be closed to a citizen who is able to establish a prima facie that the instrumentally of the state is being weaponized for using criminal force in law. Our court must be ensured there are continue of remain of the first line of the defense against the deprivation of liberty of a citizen. Deprivation of the liberty of a citizen for a single day is one day is too many. We must always be mindful of the deeper systematic implications of our decisions. So, Milord, my case, Milord, squarely falls within, Milord, these parameters of this judgment of the Honorable Supreme Court delivered in 2021 by Mailasis Chandrachud and Mailasis Banerjee.
Yes.
Yes. Now, Milord, 64 on the same judgment, kindly come, Milord. What are the parameters when your lordship will grant bail in a 226 application? While considering an application for grant of bail under Article 226 in a suitable case, the High Court must consider the settled factors which emerges from the precedents of this court. These factors can be summarized as follows. The nature of alleged offense and nature of acquisition and severity punishment of this case of conviction. This is number one. Second, where this exercise a reasonable apprehension of the accused tampering with the witness or being threatened the complainant or the witness. In our cases, all are police witnesses. Third, the possibility of securing of the presence of the accused at the trial or likely to accuse the fleeing away from justice. But so far as my son's case is concerned, it doesn't apply. Four, the antecedent and circumstances which are peculiar to the accused. In our case, my son has no antecedent. Five, whether prima facie ingredients of the offense are made out on the basis of the allegation as stated in the FIR. That's why I told you, Lordship, let them show from one FIR, my son has participated for assault of some police personals. Let them show. All are suo motu complaint. It is not that some unknown person is lodging the FIR. The police themselves is lodging the FIR. And in the FIR, my son's role doesn't transfer for involvement of a commission of offense under section 109, which is the old code of 307. The significant interest of public and the state and other similar considerations. In our case, the public was protesting, the student wing was protesting, and joined by other wings of the public. And this was a protest lady, peaceful protest lady. Because of them, it became unruly. Because they started water cannon, they have started lathi charge, they have started using tear gases. So some of the protesters became agitated and done some acts. Whether I can be responsible for that or not, this is the whole question before your lordship.
Judgment coordinate bench because senior order.
Now, my lord, one judgment which I have handed over before your lordship, because Singh,
Coordinate bench order.
the coordinate bench order, my lord, where my lord, in a 226 application, the High Court rightly said that, my lord, this in ordinary cases the remedy before the, my lord, the 437 or 439, but in exceptional circumstances, the writ court is the only, my lord, the protector. Here, my lord, the Arnab Goswami was considered, and my lord, kindly see para 3. I entertained this writ petition keeping the question of maintainability as raised by the court open. However, having to the period of detention already undergone, I am inclined to consider the prayer for bail. So ultimately, the prayer was allowed. And 3, your lordship will find from the second para, the submission of the learned Advocate General, his writ jurisdiction would not be involved with the rare and exceptional cases. So his case also, in rare and exceptional cases, the 226 jurisdiction can enlarge a person's to protect the personal liberty. So, my lord, today the question before your lordship is this: whether my custody is required or not. And my lord, the parameters which is given by the Honorable Supreme Court, I am following on the parameters. I am a student. My son is a student. Under any terms and condition, let them file opposition. In the meantime, your lordship can release me on interim bail.
Be protected.
And other 3 cases, my lord, I may be protected.
And we will give a list of cases that are.
And a list of cases may be, my lord, given to us.
Lord, before the learned advocate general starts, my lord, on facts, because it's not for us to easy to communicate. If your lordship, I've sought his leave, my lord, permission on that. My lord, from the first things that were submitted, that after the incident, may I just take one? After the incident, the seminar room where the incident happened was vandalized, and that no step was taken. Well, I could not take.
No, it's no use making submission on that because
No, I just, because all these were addressed one after the other.
no, the court is not concerned whether it was vandalized, not vandalized. Steps are being taken by different fora.
So, may I just say that this was, I have pictures
No,
that
you-
it is fully
maybe.
safe. The next
What
thing,
what you have got against the petitioner?
yes,
please.
may I say this first thing first? Submissions were made that this was a very peaceful rally. May I, your lordship, kindly see how peaceful was this rally? These are from the Strand Road.
No, but you have to show that the petitioner was responsible for this.
Yes. No, today, if he was one of those who led this rally,
Yes,
he's an FIR named accused
yes,
over here.
right.
So he has to take, if today an incident happens, can he avoid the right thing, responsibility of this whole thing? Today I lead a rally, and may I say this, there are specific statements made by him which were extremely provocative. He made a press conference the day before and said, I will not take permission. He said, I'm going to take out 2 processions. He took out 5. So he was the one who was misleading everybody. He was the one who was leading it. And my lord, your lordship, kindly consider one thing. Can I today call for a rally, meeting, procession, and say that I will not be responsible for anything that will happen in that rally? He was specifically intimated that please let us know where do you want to do, how many people were, letters were written to him. This is, his name is number 3 over here. We were sought for details. He said his basic statement in the press conference, I will not give any details. After that, can he say that he will not take any responsibility? On the factual score, these are things which the learned advocate general could not have handed over to your lordship. তুমি সুপ্রিম কোর্টে অর্ডার পেলেন কত কথা আছে সুপ্রিম কোর্টে অর্ডার এখানে হ্যান্ড ওভার করা হচ্ছে মিলট
Yes,
if the Supreme Court order was placed at length, my lord will
No,
kindly
I'll place that. Mr. Banerjee, I'll place those.
let the advocate general.
I'll place them. Yes. Now, my lord, since Mr. Muzumdar had started from the previous round of litigation, your lordship has been rightly pleased to observe that the previous round may not be essential for deciding the present prayer of the petitioner. But, my lord, I need to, my lord, take your lordship through, my lord, a very few sentences, my lord, of the Supreme Court and the High Court orders. Now, the first one is, my lord, if your lordship may kindly have a look to, my lord, page number 91. Where the order of the Supreme Court starts from page 89. Please have a look to, my lord, paragraph number 5. Nothing to do with, my lord, the previous incident, but my lord, only some observations of the Supreme Court. The paragraph 5, my lord, of the order of the Supreme Court dated 20th of August. In the aftermath of the brutal incident and the demonstrations which followed, the state government was expected to ensure the deployment of the state machinery to prevent a breach of law and order. It was all the more necessary to do so since investigation of the crime which took place in the precincts of the hospital was underway. We are unable to comprehend how the state was not prepared to deal with the incident of vandalization of the premises of the hospital. Pausing here for a moment, Millard. We are now dealing with a case subsequent to all these, that is on 27th of August, Millard, where Millard, the state was Millard, prepared to, take note and Millard prevent any kind of vandalism. Whatever was the preparation of the state, everybody knows, Millard, I need not dilate on that. Whether it was peaceful or not, everybody knows or not. Who instigated, everybody knows, Millard. I do not want to dilate on that, Millard. That may not be relevant, Millard, for the purpose of this case. Therefore, Millard, my first submission is, Millard, here, Millard, the state was, Millard, ready to, Millard, deal with the, Millard, vandalism. Now, what did the state do, Millard? Millard, again, Millard, with half-baked Millard instructions and Millard making this submission. Millard, there had been, Millard, at least 25 to 30 preventive arrests, Millard, on the previous night, where, Millard, people were ready, Millard, to, Millard, do certain acts of crime with, Millard, various weapons, etc. They were, Millard, preventively detained. Second is, Millard, in respect of the incident, wherever they have happened, whoever is responsible for that, Millard, there has been more than 150 arrests, but all arrests, Millard, have been made, Millard, after identifying the people, Millard, from the video recordings which were with the police, which are in the social media, which are with the media people. Therefore, Millard, when the petitioner has been arrested, Millard, the petitioner has also been identified by the police authorities, Millard, based on certain, Millard, what should I say, the materials. But this is my second submission, where these will all be placed on record. Now, Millard, kindly take, Millard, the next order of the Supreme Court, that is at page 105, which Mr. Mozumdar has also relied upon. In fact, this is the third order, because on 22nd we have two orders. The other order has not been annexed, so Millard, I don't go through that. Please take, Millard, paragraph number 9, Millard, at page 112. Mr. Sibal, Senior Counsel appearing for the State of West Bengal and the Kolkata Police, submits that while this court has permitted peaceful protest, the order should not be misconstrued to mean the authorities, but this is very important. Authorities are precluded from exercising their regulatory powers in accordance with law. Now, regulatory powers can be in two manners. One is, Millard, the regulatory powers, Millard, by way of restrictions under Article 19(2) of the Constitution, which includes, amongst other, Millard, 144 orders, Millard, now 163. Millard, the other regulatory, Millard, powers, Millard, are exercised, Millard, under the Police Act. That is why, Millard, your Lordship finds, Millard, whenever somebody wants to organize a demonstration, procession, etc., Millard, they apply before the police. If the police grants permission, they organize it. If the police does not grant permission, sometimes, Millard, they come before the court. Your Lordships pass appropriate orders. Now, Millard, these are, Millard, the regulatory powers of the police that anybody and everybody, Millard, having, Millard, right under Article 19 cannot, without regulation by the police, conduct these kinds of processions, demonstrations, etc. Therefore, Millard, the Supreme Court was very categoric by saying that the state is not precluded from exercising their regulatory powers in accordance with law. Now, pausing here for a moment, Millard, may I only briefly state once more what Mr. Banerjee has said. Now, Millard, this petitioner's son, Millard, who had allegedly called this Chhatra Samaj demonstration, was asked by the police, you please apply for permission. What are the routes? What are the numbers? so that either we grant permission or we don't grant permission. Now, my lord, this regulatory power of the police was prevented by the writ petitioner's son by flatly saying that no, nothing doing, we are not going to apply. Therefore, my lord, the first conduct of the writ petitioner's son in, my lord, denying or refusing to apply for a permission which is otherwise required under the Police Act of 1861, my lord, is contrary to, my lord, what the Supreme Court has said, my lord, in paragraph 9, first sentence of the order of 22nd of August 2024. Therefore, my lord, my second submission is that the writ petitioner's son has, my lord, not only acted contrary to law, he has also, my lord, prevented the state, by the order of the Supreme Court, to apply for permission for holding this demonstration. Therefore, my lord, the action of the writ petitioner's son prima facie is contrary to law, as well as, my lord, contrary to the order of the Supreme Court in its letter and spirit. So that is why, my lord, the first petition, the previous petition that your lordship has been pleased to deal with in the supplementary list today, they had applied before the police. Police did not permit, your lordship had passed appropriate orders. Therefore, my lord, application before the police is a precondition to hold, my lord, any procession, demonstration on public premises, on public roads, etc. So this has been defied by the writ petitioner in spite of the police, my lord, having, my lord, approached him. My lord, now, my lord, may I go back to, my lord, page 112, the next part of paragraph 9 of the Supreme Court's order. This court has not injuncted the state from exercising such lawful powers as are entrusted in terms of law. However, we categorically reaffirm that the peaceful protest should not be disturbed or disrupted, and the state shall not take any precipitate action against those who are peacefully protesting against the incident which took place at so and so. Therefore, my lord, the reminder of the Supreme Court was that you allow on the state, that you allow the peaceful protests, but do not take any precipitate action so long the protest is peaceful. Now, my lord, what had happened, everybody knows. On 27th, my lord, at whose instant it became violent is a matter of controversy which is to be required to be dealt with, my lord, in an appropriate case. But things had happened, or, my lord, things had turned violent. Therefore, in terms of the order of the Supreme Court, which was not required, but in this case, my lord, there was an order of the Supreme Court. My lord, the police had, my lord, the authority to take appropriate action. Now, what are the prima facie allegations against the petitioner? The first allegation, my lord, I've already said that they did not, or he did not obtain permission, despite, my lord, having been asked to do so. But the second part is, my lord, the writ petitioner's son, my lord, was present, my lord, at Strand Road, my lord. He was leading a procession over there. Now, this procession, my lord, once it reached Babughat, it turned violent. My lord, this my lord, section of this demonstrators, my lord, they have burnt the police bikes, they have vandalized, my lord, private cars, they have assaulted police, and even Mr. Muzumdar's in another capacity, the officers of Mr. Muzumdar, that is, my lord, RPF personnel. Now, they have these persons, my lord, under the leadership of, my lord, this writ petitioner's son, my lord, have caused these things, my lord, at Babughat. But one of the surgeons have lost his eye. My lord, that may not be very relevant for the petitioner's concern, or, my lord, taking him into custody. But the fact remains, my lord, there has been, my lord, these kinds of activities on the part of the petitioner, based on which, my lord, cases have been registered, and Millard, he has been taken into custody. Now, Millard, please consider one thing, Millard. But I will not deal with Millard, address your Lordship Millard on the merits of the allegation, on the merits of the FIR, on Millard, the veracity of the allegations in the FIR. But Millard, when Millard, there are prima facie materials which have not been disputed by the petitioners. Number one, did he organize the agitation? He does not dispute that. He never said that he is not one of the organizers. As Mr. Banerjee was saying, Millard, there cannot be, Millard, any leaderless demonstration. Millard, there has to be a demonstration under the leadership of a person, a party, any other body, club, society, etc. Why? Because somebody has to take responsibility. Here, Millard, this was a case, Millard, which was apparently a leaderless, Millard, agitation, when the police, through their, Millard, internal sources and through intelligence, could make out, of course, Millard, through social media as well, that he was one of the organizers. Millard, he was asked to take permission. He did not take permission. Therefore, Millard, even if, Millard, there has been, Millard, a loss of 1 rupee government property, Millard, the writ petitioner has to take responsibility. He cannot shy off by saying that the police has not discharged its duties. He cannot shy off his responsibility by pointing fingers at the entire administration of the state. Therefore, Millard, the prima facie, the allegations, case against the petitioner has been met out by the petitioner himself in the writ petition. Please take, Millard, a few paragraphs of the writ petition. Yes. Millard, please take, Millard, paragraph number 10. That the petitioner states that on 26/8/2024 in a press meeting, the petitioner's son had expressed his idea of conducting a peaceful protest march on so-and-so by the students for the protest for justice against the manner in which investigation was carried out by the state police authorities. The idea behind organizing such protest march was to peacefully agitate against the malafide actions of the state police authorities and to seek justice against the commission of such heinous crime offense. The peaceful protest was organized and led by the petitioner's son on 27th of August. But he has made out a case for himself that he was the organizer, he was the leader. Now, whatever has happened thereafter is known to everybody. Therefore, Millard, even if, Millard, a case is made out that the petitioner's son is not personally involved, he even did not throw a stone, assuming, Millard, the best case for the petitioner. Or take an example, a higher example. The writ petitioner was leading the protest from his house. He was not on the streets. Take the best case for him. Then also, Millard, please consider, Millard, whether the writ petitioner's son can, Millard, shy away from the responsibility from whatever has happened. Good, bad, indifferent, who's responsible, not responsible, but that is subject matter of investigation, Millard. That cannot be, in my very respectful submission, looked into or considered, Millard, at the threshold stage. Because I have not filed my affidavit as yet. But, Millard, from the accepted, Millard, your lordships have held that judicial admission is the highest form of evidence. It is higher than, Millard, evidence from the box. Because this is not an evidence which is coming from cross-examination. even if he withdraws this writ petition today, my lord, he will be bound by this admission throughout his life. That is our High Court's judgment. Therefore, my lord, paragraph 10 is categoric that he is the leader, he has organized. Therefore, my lord, he cannot shy off his responsibility. Now, kindly take, my lord, what is the defense? Defense is paragraph 11 of the writ petition, same page number 7. That the writ petitioner further states that on the event of 27th, when the petitioner's son was in a reputed media broadcasting house being so-and-so for interview in the panel, to the utter shock and surprise of the petitioner's son, the petitioner's son was suddenly detained by the Moidan police station from outside the media broadcasting house and was taken into custody by the concerned police authorities illegally and arbitrarily in connection with so-and-so cases. Then Millard, the other Millard submissions which Millard all falls from Millard legal analysis. Therefore, Millard, when Millard the writ petitioner son, the writ petitioner says that a son had organized the rally, therefore, Millard, the writ petitioner's son has to take responsibility. And Millard, we have evidences to show. We are going to annex those all with the with our opposition. That Millard, the writ petitioner's son, was involved in all these brickbatting and Millard the damage of public property, and therefore Millard, he cannot Millard today say that he has to be let off at the interim stage. Millard, he had applied before the competent authority, that is the learned magistrates court. It has his prayer for bail has been rejected. Therefore, Millard, it does not, Millard, in my very respectful submission, call for any interference. Now, Millard, the extraordinary circumstances that my learned friend was talking about. Yes, he's right that this is an extraordinary circumstance. This is an extraordinary case, Millard, which requires that people like the petitioner's sons should be, Millard, dealt with in an extraordinary manner. Otherwise, Millard, leaderless demonstration will continue from tomorrow. Nobody will come before this court seeking permission for a possession. Where this is not a case, Millard, where Millard, the petitioner's son was not reminded of his legal obligation to apply for a permission. His son was reminded. He flatly says in the open forum that I'm not going to seek permission. Millard, a person who does not care for the minimum law, even before organizing this protest, Millard is trying to, Millard, project himself, Millard, as a saint today before this court. The reason being that he has been arrested, where Millard, but I'm not concerned about the police being, Millard, assaulted, battered, injured, etc. What about the government properties? What about the private properties? Therefore, Millard, please consider, Millard, whether, Millard, this petitioner's son can be, Millard, shown the same leverage, or, Millard, whether the petitioner's son can be, Millard, considered in the same platform as that of, Millard, another accused who is picked up by the police, rightly or wrongly. Paragraph 10 of the writ petition, Millard, after paragraph 10, Millard, in my very respectful submission, Millard, law cannot come in aid of the petitioner, Millard, who does not care for, Millard, the law of the country, who does not even care for the order of the Supreme Court. Supreme Court says that the state will continue with its regulatory power. State invites him, please come and make an application. Therefore, Millard, now kindly take, Millard, Arnab Goswami's case. My learned friend had, Millard, relied upon Arnab Goswami's case. Arnab Goswami's case, your Lordship is much aware that, Millard, it arose of, Millard, a journalist who had, Millard, made certain comments, based on which, Millard, FIRs, multiple in numbers, Millard, were registered throughout the country. In that background, Millard, the writ petition, the petitioner over there, Mr. Goswami, goes before the Honorable Court Primarily, my lord, the case was for transfer of investigation to the CBI. That was, my lord, the primary, my lord, prayer of Mr. Goswami, if I am not wrong, subject to correction. But I can't find out the prayer right now. But if I'm wrong, but I'll stand corrected. Now, please take, my lord, the paragraph which my learned friend realized.
You should paragraph 1.
It's at paragraph 1. No?
1 and 3. 1 and 3.
Yes.
Identical. Same thing.
Yes, but in paragraph 2, my lord, the various complaints have been recorded and the genesis of the FIR, my lord, have been stated over there. Now, please take, my lord, the paragraph numbers are not matching because I have got a SCC copy. My learned friend had referred to paragraph 64 and 67. These are not matching with the one, my lord, I have. Millard, if the I don't think that the paragraph numbers will match, but Millard, it is about 6 or 7 paragraphs, Millard, from the bottom. Millard, the paragraph starts with before we conclude. Millard, about 10 paragraphs, Millard, from the bottom. That Subramaniam, Swami, and all that, Millard, have been quoted. Or Millard, a paragraph starting with, in view of the clear legal opinion, legal position. But it would be Millard 3 or 4 pages, Millard, before the end. But in my copy, Millard, the last paragraph is para 67. I was referring to para 56, say about 11 paragraphs from the end. But if your Lordship may kindly come to any one paragraph, the starting point, where I'll try to assist your Lordship. Towards the end.
Paragraph 44, I have between paragraphs 11 and 15. Now it is in this background, paragraph 43.
It is in this background. Let me find out, my lord.
The High Court has dwelt at length, paragraph 42.
My lord, Romila, Thapar and all, my lord, your Lordship has crossed those paragraphs.
Can I just suggest something that I'm sending him a copy of the Supreme Court judgment just now, if you could see that. I'm sending it.
In WhatsApp.
Okay, in WhatsApp, I'm sending it.
Please send it.
WhatsApp.
Prima facie evaluation of the FIR and the grant of bail, in bold it is in somewhere close to that.
My lord, your Lordship may kindly come to the direction portion.
Yes.
Please come towards the bottom, the direction portion.
Yes.
Before the direction portion, the paragraph just previous to that is we find no reason.
I'm just lost.
Yes, so am I. Mr. Muzumdar, if you could kindly come to the rescue of the court as well as me.
No, no, which portion? Direction portion?
Which para, Kishore, you are?
Paras are not. No.
In my copy in 2020, volume 14 SCC, it is para 56 before we conclude. There are about 12 paragraphs from the end.
We are not that. We are not that Arnab Goswami. After that 2021
Volume 2.
SCC.
Oh, I'm so sorry. Give me the citation. Please give me the citation.
There are two.
Yes.
Give me the citation. Please
One
give me the
is
citation.
but because of the news channel, different parts of the India, different. FR was
It's 2021 to SCC 427.
That's why we are sending it at once, not going from the courtroom. I'm just sending it to you.
2021, volume 2,
SCC 427.
427. I'm so sorry, Milord.
I am sending.
sorry.
Just look at your WhatsApp. I'm just now. Dinda is sending it from out just now.
Mr. Muzumdar has so high opinions about me. He said that Arnab Goswami, Mr. Dotto knows.
I learned it from you. This judgment I learned it from you.
Yes. At times that creates difficulty for me. Yes, but I've got that, but I'm so sorry, but I wasted a lot of your lordship's time, Millard. Now, please take, Millard, paragraph number 64.
Yes. That is what he was referring to.
Yes, but before that, 62.
62, yes.
Now, in this backdrop, Millard, the backdrop is very important. Well, I have, Millard, shown your lordship what is the backdrop of our case.
Mhm.
Now, in the backdrop of Arnab Goswami's case, Millard, the Supreme Court is, Millard, starting from para 62. It becomes necessary to advert briefly to the contents of the FIR in the present case. The FIR recites that, etc. Well, we did not go through that. Then para 63.
Mhm.
The petition before the High Court was instituted under Article 226 and Section 482. While dealing with the petition under 482 for quashing of the FIR, the High Court has not considered whether prima facie the ingredients of the offence have been made out in the FIR. Millard, full stop. I need not Millard submit anything more, Millard, in the backdrop of paragraph 10 of the writ petition. But this is an admitted case that he has organized. It is an admitted case where there has been so much loss. Who is responsible? That is the subject matter of investigation. Today, Millard, we cannot come to a conclusion prima facie that a person who himself claims to have organized the program is not responsible for whatever has happened. Which, Millard, in my own humble way, Millard, I say a leaderless demonstration. There cannot be a leaderless demonstration. No one else have also, Millard, claimed responsibility as of now. Then, Millard, skipping over, Millard, paragraph 63. Now, please take Millard 64. While considering an application for grant of bail under 226 in a suitable case, the High Court must consider the settled factors which emerge from the precedents of this court. The factors can be summarized as follows: the nature of the alleged offence, the nature of the accusation, and the severity of the punishment in the case of a conviction. Whether there exists a reasonable apprehension of the accused tampering with the witnesses or being a threat to the complainant or the witnesses. The possibility of securing the presence of the accused at the trial or the likelihood of the accused being from justice. The antecedents and the circumstances which are peculiar to the accused. Whether the prima facie ingredients of the offence are made out on the basis of allegations as they stand in the FIR. But I add a half sentence to it, Millard, on the basis of paragraph 10 of the writ petition. Then the significant interest of the public or the state and other similar considerations. Millard, forget about, Millard, public properties. Millard, private properties have also been damaged. These principles have evolved over a period of time and emanate from the following, amongst other decisions. These principles are equally applicable to the exercise of jurisdiction under Article 226, but I don't detain your lordship with the rest of it. Therefore, my lord, in a case where, in an admitted case, whether an accused can come and say that this is such an extraordinary situation where he cannot be kept in custody even for a minute, that he cannot pursue his ordinary statutory remedy, but under, my lord, I do not know, Mr. Muzumdar will correct me, 439, whatever is the section now under BNSS, he has to apply over there. Therefore, my lord, this is not a case, my lord, where, my lord, this is an admitted case, my lord, where, my lord, a writ petitioner cannot be shown, my lord, any latitude, my lord, in the backdrop of whatever has happened. Now, my lord, who's responsible, who's not responsible, is to be looked into later on. Now, kindly take me the FIR. Well, my learned friend was very vociferous and saying that the police is interested to protect some other political party. Now, how does he say so? He says so, my lord, from the FIR. Please consider, my lord, after paragraph 10, my lord, whether all these submissions, my lord, can be taken note of by the court. I would be respectfully submitting, my lord, cannot be. This is for your kind information that on so-and-so, near about so-and-so, information received from anonymous telecaller that some agitators assembled at so-and-so place and has been showing the agitation accordingly. The undersigned, along with available officers and force, including lady force, reported at so-and-so place, known as so-and-so, and found that 150 agitators, including ladies, under the banner of so-and-so, called by Navanno Vision by Provita Shayanlai and Shumankar Haldar.
Which
I'm
page?
sorry? I'm sorry?
Which page are you placing, my lord?
Oh, I'm so sorry, my lord. It's page 120. So, my lord, there is no dispute that he had given the call. He was leading it. He was found at, my lord, this Dorina crossing, unlawfully assembled, thereby blocking so-and-so without permission from the concerned authority, which caused disruption of normal vehicular pedestrian movement. They raised slogans by shouting over the issue of the ongoing Ajikot hospital matter. They were too much violent mode and they were repeatedly appealed not to break law and order situation and to do peaceful protest, but all such requests fell in deaf ears. Meanwhile, some agitators being agitated also damaged some flexes of TMC party which were affixed at different places in and around the vicinity of the said spot. After that, they were again repeatedly requested not to do such type of illegal acts, but all efforts were in vain. They committed subversive activities by endangering public safety and tranquility. However, some of the agitators having their conspiracy became furious and deter on the police personnel for discarding their lawful, it should be discharging their lawful duties and physically assaulted them on the police personnel due to they were sustained injuries and sent to SSKM hospital over the incident. Agitators, namely so-and-so, so-and-so, at such and such, under such and such act. Therefore, my lord, my learned friend was very categorical in, my lord, pointing one part of the FIR to show that, to at least make out a case that the police was so-called partisan. But, my lord, in a case where, my lord, somebody admits, my lord, law admits that he is not going to abide by law, as well as Supreme Court decision, when in my very respectful submission, does not, my lord, cannot come before a court of equity. Finally, my lord, he is before a court of equity. Somebody coming before the court of equity for enforcement of a fundamental right cannot say that I'm not going to.
Sure, please see your WhatsApp. I've sent you a document. I've handed over the document to court already.
Yes. Well, kindly give me a moment.
The letter I had handed over, that I've sent it to
But
him.
I'm sorry, my lord, I cannot, my lord, assist your lordships for a couple of weeks more physically.
This is a letter addressed to the petitioner's son.
Yes, yes. I know this. I know this. Kindly have a look to this letter, my lord. But this is a letter. Have you given it to the court, Mr. Banerjee?
Yes, yes.
I have given it to
So
court.
kindly see the date of this letter.
Mm.
24th of August. Kindly see the addressee number 3. We have learned from the press conference held by the members of so-and-so at such and such time that a protest event called so-and-so for August 27 with specific demands. The press statement suggests that a significant number of people from various parts of West Bengal are called to participate. We have also noticed multiple social media posts encouraging mass mobilization towards Navanno, the administrative headquarters of West Bengal, on 27th August. Given that Navanno is a highly so-and-so place, 163, etc., previous calls for the Navanno vision have resulted in such and such. To ensure peace, in line with Honorable Supreme Court's direction, and to facilitate peaceful protest, you are requested to apply for permission to organize such protest processions through proper channels. Compliance with the guidelines, etc., is also required. Name of the persons, gathering points, estimated number, route, duration, list of volunteers, vehicles, contact numbers. Now, what is the reply? Mr. Banerjee, do you have the reply?
Reply to me?
Possibly there is no reply to this.
Yes, possibly they had not applied. Therefore, my lord, this person does not even care for the Supreme Court's direction. Please consider, my lord, he is now before the Court of Equity, asking for bail. But I will respectfully submit, my lord, we have all, but again, my lord, in bits and pieces, made and getting instruction and apprising your lordship of that.
There
I
is,
think he said,
I'm told.
Yeah, I've also forwarded it to him. Your lordship, he replied, "Kagaz hai."
It has been forwarded to you.
please recollect, my lord, that provision of the Constitution, I think it is Article 144 of the Constitution.
I'm sorry, my lord,
If your
that's not
lordship
the
is having
Reply to
reply টা কোথায় আছে? তাহলে আপনি
এই যে,
উপরটা send over করেন।
এই সাদাটা,
custody.
এই সাদাটা, এইটা, হ্যাঁ। So please have the Constitution, my lord.
Yes.
If your lordship is having one,
Yes, should
That's
be.
sure it's a reply.
Constitution.
Reply.
ওটা
it's
reply
just come to my mind while arguing.
hand over করেন কেন?
Yes. Kindly see, my lord, Article 144.
কি হলো আমি দেখতে পাচ্ছি না কেন? Yes.
But I
140.
hope your lordship can hear me.
Yes, yes, I can see you also.
Reply.
No, এটা তো প্রবীরের reply. No, Shayan has not given a reply. প্রবীর has given.
So 3 of them are the organization. If one of them,
Yes,
Please take me Article 144.
yes.
All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. So with all authorities, including the judiciary, has to act in aid of the Supreme Court. And when an individual says, through his act and conduct, that I'm not going to act in aid of the Supreme Court, or I'm not going to follow the orders of the Supreme Court, I'm not going to apply. Therefore, Miller, please consider the Miller entire gamut of the situation, Miller. He's not that innocent that he's pretending here to be. He's not a person, Miller, who has been picked up, because exact number I don't have with me, but at least one day back, I knew, Miller, more than 150 arrests have been made. That apart, Miller, preventive arrests were made about more than 25. Exact figures, Miller, I cannot give at the moment. Therefore, Miller, it's not that, Miller, he is the only person who has been picked up. Others have also been picked up. He has to take responsibility of whatever has happened, because he is the claimed leader of the protest that was organized on that particular date. So these are my very respectful submission, Miller. Kindly do not pass any interim order. Please grant them liberty, whatever recourse they have as per the BNSS. So far as here, Miller, we'll file our affidavits to demonstrate that the petitioner has not been unlawfully picked up, and there are prima facie evidence in the form of photographs and all that about his involvement, and therefore, Miller, he has been rightly apprehended. And Miller, he is now in the process of law.
I would like to have a few answers.
Yes,
From-
Miller.
Please tell me, how many permissions have the state granted to the number of protests, demonstrations that are going on to object the incident that has happened? How many formal requests have been made? The 14th of August 2024, the night, to reclaim the night by the women, did the police grant a single permission to anybody? And this protest is going on not only in the city, it is throughout the state, throughout the country, and has also crossed the borders, right?
Yes. Yes.
How many have you given? Number one.
Yes. Yes.
Second, how influential is the petitioner? Since when is he doing all these activities? Prior to the Arjikor incident, was he known to people? Did he have any role, any type of significance? Any antecedent as has been recorded in Arnab Goswami's matter?
Yes.
Next is, you say leader. He has to accept that he is a leader. It is just like Gaye mane na apni moral type of thing, right? He doesn't have any background and people will consider him as a leader, right? And you want this person to be kept in custody for whatever reason. The principal of the college where the incident took place, did the police take him in custody to find out what has happened? Can he not be considered as a leader of that organization? Is it not required? Next is the inflammatory speeches that you say, which were given by the petitioner, a petitioner's son rather. What about the inflammatory speeches that are being given out by the political leaders? What steps have been taken against them? This person, does he have any political inclination, any affiliation? Is he in active politics so that you can pin him down? Now, the people in general, in this incident, we are concerned about only this incident. Don't mix this up with other matters.
Correct.
One of a kind,
Correct.
shocked the conscience of the mankind, I may say, right? So in such a situation, when everybody is protesting, when the persons who are actually responsible for the incident or maybe was in a position to do something or not to do something, how many of them are in custody? These are just the general queries
Correct.
which passed on through the mind of the court when you were making submission. I just want
Correct.
answer to it.
I'll try to, Miller, dispel all doubts, Miller, from the mind of the court.
Yes.
First is, Miller, the law requires permission to be taken. Your Lordship is right in saying that in these protests, how many permissions have been taken?
Many protest permission is
Please come back to page 112.
Yes.
May I also just inform you one thing, that a number of permissions have been taken, a lot of
Yes, I know that. I'll make those
petitions
submissions.
have been filed in this court.
Wherever permission has not been taken, what action the police has taken. Now, please consider, my lord, paragraph number 9, where the Supreme Court has said this court has permitted peaceful protests. Number 1. Therefore, my lord, the Supreme Court has permitted peaceful protests. My lord, if today, my lord, I go and apprehend somebody, my lord, in those cases where, my lord, we have not done so, my lord, at least there is no allegation, then, my lord, we'll be violating the Supreme Court's order. Because the Supreme Court had permitted peaceful protest. Now, what is the difference between the other protests and this protest? But the difference is, my lord, that is what we had told them, that this is a high security zone where 163 or previous 144 has been imposed. The other processions, the other peaceful protests, wherever they are happening, whether, my lord, it is in the Southern Avenue, whether, my lord, it is in the Tambajar 5 point crossing, etc., my lord, there, my lord, 163 or 144 has not been imposed. Therefore, my lord, wherever there is a 144 imposed, possibly, my lord, again going by paragraph 9 of the Supreme Court's order, it cannot be construed that orders under 144 is also to be brushed aside. But even then, my lord, assuming that, my lord, our, my lord, interpretation of the Supreme Court's order is wrong, assuming for argument's sake, my lord, we have brought it to his notice or the 3 organizers' notice that please obtain permission. He has not obtained permission. Therefore, my lord, the other my lord, protests which are taking place throughout the state, where, my lord, 144 is not involved. My lord, take an example, my lord, if something is to be organized, my lord, tomorrow, my lord, in and around, say, Raj Bhavan. But I'll have to ask people that please take permission. Or, my lord, he could have come before this court and said that in view of the Supreme Court's direction, we are not to take permission. People are coming regularly before your lordship, my lord, whenever permission is delayed or refused. Now, my lord, may I just complete, my lord? What is usually not brought to the notice of the court is that when permissions are granted to various political parties. Otherwise, my lord, how could, my lord, all these, my lord, agitations throughout the state by different political parties take place? Because in all those cases, my lord, permissions are granted. But they do not surface, because if you apply for permission, I give permission, why will the people come to court? People come to court, my lord, in fact, my lord, I have asked, my lord, the competent authorities to make a list of how many permissions are given by the various districts for organizing these agitations, demonstrations, processions, etc., even during pujas. So that, my lord, we can give your lordship a picture that barely, my lord, even 0.5% of the applications are not refused. Therefore, my lord, the other agitations, my lord, which are taking place, my lord, if I today take action against them, my lord, it would be violation of the Supreme Court's order. Now, my lord, if today I have violated the Supreme Court's order, take an example. That in this case, by virtue of, my lord, this arrest, or by virtue of registering the FIRs, I have violated the Supreme Court's order, my lord, he has to go back to the Supreme Court, saying that the state has violated the Supreme Court's order. Now, he cannot, my lord, after accepting that he was the organizer or leader, whichever is the appropriate term, he cannot say that he's at par with the other accused persons in other cases. It is correct. My learned friend says that extraordinary. The extraordinary circumstances in the reverse manner. Extraordinary against him. Otherwise, if I release him today, but I have to release more than 150 persons.
What credibility does this petitioner have? Will you please say?
Milord, may I play
I'm
one
sorry,
thing?
I'm interrupting you. Kishore, please see your WhatsApp once.
Milord, accused for the first time is also equally responsible for the crime. One need not be Milord, a history sheeter.
He claims he's a political worker. So that's please see your second paragraph.
Last one.
That last one that I just now sent on your WhatsApp.
Second para.
First page, I am associated with
Many social organizations like RSS, Vishwa Hindu Parishad, which is the youth wing of Bajrang Dal from South Kolkata. I am Milan Kendra Pramukh of Bajrang Dal up to 2023. I am a member of the new committee of Bajrang Dal, Shuman Kullan Das of 99 Ward. Also, and so on. He says that he is affiliated.
But kindly
No,
consider
this,
confessional
Acha, what is this? What is this?
this is a statement under 161.
Acha.
statement.
No, 161 statements are not to be laughed at.
No, one confident.
If you don't have 164, then there will be no prosecution. then.
I do not, as of now, I don't find him to be a very influential person who can garner so many people by only one call.
No, that is his
there-
admitted case.
Well,
So it is
let him
his
admit
admitted,
whatever he does. Let him admit. You have to find out whether
No, we have our evidence, Milord.
proper.
Milord, my submission is that in the backdrop of paragraph 10, he cannot say he is innocent. In the backdrop of paragraph 10, he cannot say that he is not responsible. And apart from that, Milord, my evidence is why I have picked him up, Milord, I'll place before the court. But not at the threshold that he should be let off. In the backdrop of paragraph 10, take it up on Tuesday or Wednesday. In one day, Milord, I'll file my affidavit in opposition.
Is his custodial interrogation so very important?
Very important, Milord.
What powers does he have to tamper evidence? Will he flee away, not give any witness when called for? These are the things which have been laid down by the Supreme Court at the
Definitely,
time of
Milord. In an
consideration of
appropriate,
debate,
yes.
right?
Well, in
So,
an appropriate case where Milord an accused comes and denies that I am in no way involved, in those cases, Milord, these parameters apply.
and one of the documents which have just been handed over by Mr. Banerjee here is a letter written by one Probir Das, who
Yes.
happens to be one of the persons in the same letter to which the petitioner was addressed, calling
Yes,
for
sir.
the number of people to give details and seek for permission, right? Now,
Yes,
this
yes.
person, Probir Das, he mentions that with profound respect, please forward this to him also.
May I just see that letter once? Which one is that? I'll just-
26th of August 24, just now you handed over.
yes, I'll just see it once. When
Yes.
Reply to 24th letter.
Yes,
Reply
yes,
to 24th letter.
Right. It was forwarded. Possibly it was forwarded just now to you.
Because
It
No,
has
I have
al-
not received it. Is it an email?
it was forwarded.
Yes, it's an email. Yes.
Yes, I forwarded.
Yes. It's an email communication.
Right.
Right. With profound respect, leave the
Yes,
first
yes.
paragraph. The same would be a march towards Nobanno, the state secretariat, the student society, as well as the general public at large, irrespective of their caste, creed, religion, political identity, would be a part of this rally. The rally would be a means of a democratic and a non-violent protest. We have come to know from reliable sources that miscreants engaged by the ruling dispensation in the state would try and use tactics to defame the students and the
Yes.
general public at large by using violent and other malicious means.
Yes.
They would also take resort to various tactics to attack the protesters and the police personnel and defame the society. Steps may be taken to avoid such undesirable situation,
Right.
not
How many
direct from Probir, but from one of the
Right.
addressees to the notice. They
Right.
fall on the same plane. I
Yes,
do not know whether you have arrested Probir or not.
Yes, he's arrested.
He is also arrested. Very well. The
And how many students were found in that agitation, everybody knows. Finally,
it has crossed the boundaries, Mr. Dotto. Everybody, not only students, children, women, men, everybody.
Millard, I would be Millard. I would Millard try not to make any submission on those, because Millard, that would be bordering on the merits of another case.
Yes. So let us not go into those.
Yes, yes.
We
Therefore,
will.
Millard, I very respectfully submit, Millard, this is an admitted case.
Yes.
He does not anywhere say that he is nowhere associated. He
Right.
points out fingers at the police. That's his case only.
But that is democracy also, isn't it?
No, democracy, Millard, the expression, Millard, democracy, Millard, I think, Millard, was best, Millard, explained by our late president, Mr. Pranab Mukherjee, who said India is a democratic country because all kinds of persons, Caucasians, Dravidians, Mughals, the descendants of everybody can live together. I think, Millard, that is the best definition of democracy, Millard, that I've ever, Millard, come across. Now, Millard, here, Millard, again, Millard, democratic rights or fundamental rights under Article 19 is not unregulated and unrestricted.
But do you
We have-
not
sorry.
think that the manner in which you have treated this person is a pressure tactics not to continue with the protests?
Millard,
Persons who were actually responsible for the act for which they are protesting, they are yet to be identified, steps taken against them. Now you try to nab these people who are protesting.
No. Millard, kindly, Millard, do not, Millard, look at it from that point of view. But hundreds and thousands and lakhs are protesting.
Yes. And you
But in
pick up
those-
somebody who's
No,
trying
then no, Millard, in that case, Millard, people will go away. But it is one thing to, Millard, peacefully protest.
Yes.
It is one thing to, Millard, address your lordship. It is another thing to use unparliamentary language while addressing your lordship. Please consider the difference.
Yes.
Therefore, Millard, if 10 people agitate and 2 people of them, Millard, act in some other manner, but I have a right to, Millard, dissociate the 2 persons from the other 10 people. That regulatory right the police must have, otherwise, Millard, police will lose all its powers. Now, therefore, for example, the junior doctors, where the Supreme Court, Millard, has said, expected that the junior doctors will go back to work. In these orders, Millard, which my learned friend has annexed, but the junior doctors have not gone back to work. Some of them, of course, have gone back. But we have not taken any steps against them. Yes, there are, Millard, certain, Millard, statements that is something different, but finally no steps have been taken. Therefore, Millard, if it is within the 4 corners of the law, any action within the 4 corners of the law, to the liking or to the disliking of the state, that is one thing. And if something is done beyond the 4 corners of the law, then, Millard, the police cannot be made numb by saying that you have not taken steps against the peaceful ones, therefore you cannot take steps against the persons who are not organizing it or conducting it peacefully. So that is what the Supreme Court says. Therefore, Millard, I very respectfully submit, Millard, that these are the matters, including this matter, in my very respectful submission, ought to be looked into by the Supreme Court. Because otherwise, Millard, the paragraph 9 of
till you bring this matter to the notice of the Supreme Court.
No, I have got no obligation, because my learned friend's client has brought it to the notice of this court.
Yes.
Well, my submission is, because before the Supreme Court, we are not parties. Supreme Court has taken suo motu cognizance of the matter. But I have got, Millard, different a different interpretation of the Supreme Court's order, but I have made that submission. Our High Court has not accepted that. Therefore, I will not dilate on that. Therefore, my lord, what I was trying to say is that we have acted, the Supreme Court was conscious that if I allow a peaceful protest, I should not tie the hands of the administration if it is not peaceful. Therefore, my lord, the paragraph 9 has been couched in that language. While, my lord, protecting the rights of the peaceful protesters, the Supreme Court was conscious that the administration should also not be stopped from taking action. Now, my lord, today, my lord, the administration has taken action. In 19 out of 20 cases, the administration has not taken any action because, according to the administration, those are peaceful. Now, the one in which it is not peaceful, everybody knows that. Well, can it be said that a peaceful protest and a protest which is not peaceful should be dealt with in the same platter as that of the other one in terms of the Supreme Court?
If the protest or the rally was initially peaceful and then somebody else hijacked it and made it unruly, why will you get hold of the person who organized the peaceful rally?
No. He's not only the organizer. He was a person who led it from Strand Road. It went on till Babughat. At Babughat, it became violent in his presence.
And Babughat is Babughat within the 144 zone. It
No,
isn't. Then
violent.
You find him to be very unruly in Babughat. You arrest him.
No damage to. It's not unruly only, my lord. It's not only unruly, my lord. At Babughat, my lord, several properties were damaged. Private properties.
Was he personally responsible
Yes,
for this damage? Did you find him pelting stones or anything?
Yes.
The photographs that have been produced.
But I do not know which photographs have been produced, my lord. The little instruction that I have.
Do you find any of the photographs where this person? So how do you know whether these photographs are related to this incident?
These are all, as far as that incident, that place, all are of Strand Road.
I do not know.
Then we put it on
So
affidavit.
that will not. I will
put it on affidavit.
I will apprise the court by way of an affidavit. I am saying that give me 1 day time. Give me 1 day time.
Yes.
But he is not that innocent. This is an admitted case. Now, only thing which is troubling the court is his personal involvement.
Right.
But Millard, I have a twofold submission. As I said.
1 minute. And not only his personal involvement, he tries to make out a face of himself and somebody from behind is running the show. You don't get hold of the right person. You hold the person who is there in front.
Very well. Millard, may I, Millard, remind your lordship, Millard, of the various orders that your lordships pass. That when the state refuses a permission, somebody comes before the court, will your lordships provide those conditions that give the name of the organizer? What is the purpose? If there is any damage, he is made responsible. Therefore, my lord, assuming for argument's sake, for the time being, that he had not destroyed any property, assuming for argument's sake that he was having both of his hands in his pockets when everything has happened, then also, my lord, in view of paragraph 10, my lord, he cannot say that I have no responsibility. And in fact, he has never said so. Please come back to, my lord, paragraph 10 onwards, but I was emphasizing on that. But how can, my lord, these submissions be made in the court when there is no, my lord, averment to in the writ petition? But I am not, my lord, contesting a case where what has been said verbally is part of the pleading. But I am not taking.
You have to see that the writ petition has not been filed by the person who is in custody. It is the mother
Right,
who just comes
right.
So
Therefore,
she may not have all information either.
No. But I have not taken that point whether the mother could have moved this petition or not. I have not taken that point. The Shayan Lahiri could have himself also moved the writ petition by furnishing a wakalatnama from the
in custody. Yes.
Now kindly take me at paragraph 10 once more. Then kindly take me at paragraph 11 once more. Then paragraph 12 comes suddenly that several FIR has been registered within a short period of time. The state are entangling the petitioner's son in one after the other cases to harass him. The petitioner's son is aware of 3 other FIRs in which he has been arraigned as an accused, and he expresses his great aspersion that he will be shown arrested in such FIRs. One such FIR being etc., etc., etc. Where does he say that he was in nowhere involved? Then kindly take me to paragraph number 13. That the petitioner states that the investigation has been taken from Moidan PS by so-and-so to the shock, surprise, etc., overzealous police machinery, etc. Then 14, that the whole might of the state has been thrown into action to curtail the petitioner of his liberty by hook or by crook. The lodging of the instant FIRs are nothing but glaring examples of false implication, etc., etc., etc. Where so many high principles has been averred, but half sentence has not been said that the petitioner's son is in no way involved in any of these activities. The matter would have been completely different.
Paragraph 16, I
Yes,
can
yes.
see.
Based on entire suspicion.
No, he says
specific-
he is innocent and in no way connected with any offences, far less offences alleged against.
Yes.
So there
It
is
is
a
essential that no role of the petitioner has been made
sentence
out in the
there.
written complaint. Now, written complaint, FIR is not an encyclopedia of facts.
Yes, yes.
Therefore, if I have to make out a case 2 plus 2 is equal to 4, then no FIR stands. Therefore, in this entire thing, how can a person who organizes come and say that I've got no role to play and the petitioner has been picked up at the choice of the state? And why? Of so many persons, hundreds and thousands were there. Now, why will I pick up one unnecessarily when there are so many other accused or so many other persons? And in fact, we are still in the process of finding out the others.
Yes, your reply, please.
My reply, there is in the code of criminal procedure earlier code and a new code, there is not a single word your lordship will find that the vicarious liability. Your lordship will find in the IPC and a new BNS also that whoever committed the offense, he will be punished. This is the language always. So in the criminal law,
would your lordship permit me 2 more minutes? 2 more minutes. I think I need to show your lordship the Police Act. I don't know whether the Police Act is with your lordship or not.
I don't think so. It's here. Police Act.
I tried to download it and give it to you.
No, it must have been here because of the change of determination. Books may have. Please read out what you want to submit.
Yes. Well, first is section 30 of the Police Act.
Yes, please.
Yes.
this will be PRC, not PRB.
No. I am talking about the Police Act of 1861.
Yes.
Hey, Dinda, please pass on one copy to the court.
Yes, my lord. May I?
Yes.
But I'm handing over the iPad.
It will be put on the screen.
Oh, they can put up on the screen.
Yes.
You never get such good assistance in any court. A PDF.
Yes. Section.
In fact,
Section
now I have to gather a lot of strength to speak in my normal voice.
Sorry, I didn't hear you.
But I'm saying that to speak at my normal voice,
Yes.
I need to gather a lot of strength, physical strength.
Is something wrong with you?
This is sufferer.
Yes.
Cardiac failure.
Oh, I'm so sorry. I didn't know it.
That's why it's not been coming for the last.
That's why I've not gone to the court for a month.
Please don't strain yourself much.
No, I'm not straining myself, but
His
You
voice
you
is
can
still
be soft. I can hear you clearly.
yes.
Yes.
But is the Police Act on the screen?
Yes, yes, yes.
But if you lucky,
Section
kindly take me section 30.
Yes.
The district superintendent or assistant superintendent of so and so, as occasion requires, direct conduct of all assemblies and processions on public roads or in public streets or thoroughfares, and prescribe the routes by which and the times at which such processions may pass. Then we got the license part. He may also, on being satisfied that it is intended by any person or class of persons to convene or collect an assembly in any such road, street or thoroughfare, or form a procession which would, in the judgment of the magistrate of the district or of the subdivision of a district, if uncontrolled, be likely to cause a breach of the peace, required by general or special notice that the person convening or collecting such assembly or
Scroll it.
directing or
Yes.
promoting such processions shall apply for a license. Now, this was the letter that has been placed before my lord under section 30, subsection 2. On such application being made, he may issue a license specifying the name of licensees. If he had applied, I would have specified his name as one of the licensees. And defining the conditions on which alone such assembly or such procession is permitted to take place, and otherwise giving effect to this section. So, Millard, had he applied, Millard, we would have made him one of the licensees, provided that no fee shall be charged. Now, kindly take, Millard, section 30, subsection A, section 30A. Any magistrate or district so and so may stop any procession which violates the conditions of a license granted under the last foregoing section, and may order it or any assembly which violates any such conditions as aforesaid to disperse. So, that even after granting license, I can stop it. Any procession or assembly which neglects or refuses to obey any order given under the last preceding subsection shall be deemed to be an unlawful assembly. Then section 31 I skip over, and then kindly take 32. Every person opposing or not obeying the orders issued under the last three preceding sections, or violating conditions of any license granted by so and so for so and so conducting assemblies and processions, shall be liable on conviction before a magistrate to a fine not exceeding 200 rupees. Therefore, it is a direct responsibility. My learned friend's client's son cannot flatly refuse and say, no, I'm not going to make an application. That is what, Millard, Supreme Court is categoric, Millard, in paragraph 9. These are my regulatory powers. My learned friend says that there is no vicarious liability. I am not on vicarious liability, I am on the direct liability. Now the question is, he does not adhere to the law. He does not adhere to the Supreme Court's order. He does not take any license. Now he is only confined to saying that, where are the evidence against me? What is the direct evidence against me? You have picked me up out of nothing. But he cannot say so. He will give a call and then say that, oh, I don't have so much might to gather so many people. He may not have the might, but if he has called it, he has to take the responsibility.
Very well. It is enough. Please
Yes,
don't take any more.
More than enough.
Don't take any more strain. Take care of yourself. I would
Yes,
like to hear you in reply. First, tell me,
Yes.
we are talking about the son. How is the association that he is representing a registered one?
But this is not a registered one.
Not a registered association.
It is association of people It was formed because of the incident which took place
Voluntarily,
caused after 9th
Nothing.
of August.
after 9th of August, just name it as an association.
Association.
There is no
Because you
association
lot
as
is no
such.
various part, the students were protesting. So they formed a group called, my lord, this association, Chhatra Samaj, was Paschim Banga
Alright.
Chhatra Samaj. So there are, my lord, different field and different, my lord, college, different, my lord, school. All the students, they have assembled and form a group to protest about the barbaric incident which took place on 9th of August.
And role of the state.
All right.
And by that,
And second, Lord, I told your lordship, there is not a vicarious liability in Indian Penal Code offences and new BNS Act is concerned. So the sentence, whenever your lordship will find a penal offence, your lordship will find the sentence starting with whoever. So that person has to be take responsible for the offence caused by that person. Now, my lord, from the submission of the learned Advocate General, your lordship will not found there is single evidence in respect to present petitioner who actually, my lord, committed the particular offence. And if I take the, my lord, the face value of the submission of the learned Advocate General, only offence he has committed under section 32 of the Police Act, where, my lord, it's a penal offence and it is, my lord, only for 200 rupees. Now, my lord, keep these facts in one hand and, my lord, kindly take the parameters in Arnab Goswami's case, where your lordship has the power to grant release him on interim bail. My lord, may I read the paragraph? My lord, whether I am, my lord, fulfilling the category of these paragraphs or not, your lordship kindly consider. Number one, the nature of the alleged offence and nature of acquisition and severity of the punishment of the conviction. My lord, it is, my lord, 64.1. The nature of alleged offence, nature of acquisition, and the severity of the punishment in the conviction. So, my lord, admittedly, so far as the offence of attempt to murder and other sections are involved, admittedly, there is no direct, my lord, the allegation so far as the present petitioner is concerned. If at all, my lord, I could gather from the submission of the learned Advocate General, the only offence which can be attracted to me under section 32 of the Police Act, which is a fine of rupees 200 rupees.
No, further submission is that you've destroyed public property.
No, there is no evidence. So
property.
far as the present petitioner is concerned, there is no evidence. And your lordships, that also, my lord, we can, my lord, counter that argument by that reply which forwarded to your lordship. Your lordship will find there is a specific column which has been written by the Chhatra Samaj saying that the outside
They
goods.
anticipated that this could happen.
Yes, and that's what that was intimated to them. So they have their own, my lord, the IB, they have their own, my lord, the intelligence, Kolkata police. They could not find out who actually caused these offences. They should have, my lord. Kolkata police, sometimes we call, my lord, as a Scotland here. They have a better infrastructure. As soon as this mail has been committed, it was their duty to see who are the persons who are coming, who are the goons who are coming, who are trying to, my lord, disrupt the peaceful possession. That should be, my lord, looked into by them on that day itself. That we have intimated them. Second, my lord, 64.2. Whether this exists a reasonable apprehension of the accused tampering of the witness or being threat to the complaint of the witness. It doesn't appear because all the complainant belongs to the police.
No, you've read out. So
Yes.
don't repeat. Please don't repeat.
Well, these are the parameters when your lordship will consider my lord the interim bail. Let them file affidavit, what exact allegation, my lord, they have against me regarding destruction of property, regarding attempt to murder. Let them place it. Then your lordship will deny. But in the meantime, my lord, protect my liberty. This is my humble submission.
Very well. I'll pass order. But then in my chamber.
Lordship. My lord, 3 cases I have been tagged. My lord, kindly mark, my lord, the paragraph 12. I have mentioned all these 3 cases. Para 12.
You relied upon Arnab Goswami and Bikash Singh.
Para 12 of my petition.
These are the two precedents that you have relied upon.
Yes.
Paragraph 11.
Para
11.
Para 11.
Moidan police station arrest.
My lord, 11, 12. I was arrested in connection with, my lord, the Moidan police station. In subsequent para 11 and para 12, these are the 3 FIR I am directly named. My lord, kindly my lord, release me so far as these 3 FIRs are concerned, if I am at all arrested. And so far as the other cases, protect me till they file their affidavit.
State. Get me the Police Act in my chamber.
তাই দিলে তো সবাই তো মিস করবে না।
I'm grateful, my lord.
Deeply appreciated.